This session is, as you can see, on private enterprise and public benefit. For those people who don't know me, my name is Jennifer Vitruni. I'm the Director of Plans and also the Chair of the Law Council Charities Committee. And I would also like to acknowledge the traditional owners of the lands upon which we meet, the Wurundjeri people of the Kulin Nation. We have a panel of four esteemed lawyers here today. The first speaker will be Nicola Bennett, who's a Kiwi from the ACNC. Nicola has been at the ACNC since its establishment in 2012 in the registration team and the legal team. Prior to that, she worked as a registration analyst in the New Zealand Charities Commission. She holds a law degree with honours and a Bachelor of Arts from the Victoria University of Wellington. Sahanya Mendez is also a long-time ACNC staffer. She's legal counsel at the ACNC, and Sahanya has a law degree with honours as well as a Bachelor of Commerce, majoring in accounting. She provides advice to the Commission and ACNC staff about the ACNC's statutory obligations under the ACNC and Charities Act. Prior to that, she was in private practice, advising not-for-profits and charities on their governance, structuring and taxation of obligations. She's worked with a range of Australian and international organisations in the education, disability and faith sectors, amongst others. Sahanya has also served on a number of not-for-profit boards and in volunteer roles, including as a legal fellow with the International Justice Mission in Uganda for a year. Bridget Cowling is a senior associate at Arnold Bloch Leibler and is also, as I recall, the chair of the Tax Institute, Charities and Not-for-Profits Commission, and also a member of the Law Council Charities Committee as well, and also well-known presenter in the charities field. Stephen Moe is a partner at Parryfield Lawyers in New Zealand. He has worked for an international law firm in Tokyo, London and Sydney. He works with many charities as well as social enterprises and wrote a book about that topic and does a weekly podcast called Seeds, telling stories of people doing good. So the way we're splitting this panel up is that Nicola will speak about member benefits first, Sahanya will then speak about social enterprise and charity, Bridget will talk about the extent to which the promotion of and incubation of private enterprise is charitable, and finally Stephen will talk about the New Zealand perspective on the future of the business-charity divide, with special attention to structuring for impact. So could you welcome our panel, and in particular to Nicola.
Thank you, Jennifer. As Jennifer said, I've been asked to speak on the topic of member benefits. So I think I'll start by quoting the review judge, because that way it'll be more interesting. So in his decision in Inland Revenue Commissioners and Yorkshire Agricultural Society in 1928, Lord Atkin stated that there can be no doubt that a society formed for the purpose merely of benefiting its own members, though it may be to the public advantage that its members should be benefited by being educated or having their aesthetic taste improved, or whatever the object may be, would not be for a charitable purpose. However, Lord Atkin went on to state, but on the other hand, if the benefit given to its members is only given to them with a view to giving encouragement in carrying out the main purpose, which is a charitable purpose, then I think the mere fact that members are benefited in the course of promoting the charitable purpose would not prevent the society being established for charitable purposes only. So it's been just over 90 years since that decision was issued, and courts are still relatively frequently called on to determine where to draw the dividing line between member benefits that merely assist in carrying out a charitable purpose and member benefits that stray into the territory of an independent non-charitable purpose or a non-ancillary private benefit. An organisation's particular circumstances will be key in determining whether a benefit the organisation provides to its members will render it non-charitable at law or not. So some questions that could be useful to ask could include, is the organisation explicitly conferring a benefit on its members, or does that benefit arise as an incidental byproduct of achieving a charitable purpose? So an example of a benefit that is an incidental byproduct is when membership of a charity confers prestige on its members due to the nature of the purpose that's being achieved. So an example of that are the Lemon Society cases. Another question that would be helpful to ask is membership restricted or open? If membership is restricted, is that restriction necessary to achieve the charitable purpose? An organisation which restricts its membership arbitrarily and which confers benefits upon members is likely to find it more difficult to demonstrate that the benefits it provides to its members are incidental to carrying out its charitable purpose, notwithstanding the nature of those benefits. Also, what is the nature of the benefits that the organisation provides to its members? Are the member benefits token in nature and provided in exchange for membership fees, which then fund the organisation's ability to carry out its purpose? If so, providing those kinds of benefits is unlikely to render it non-charitable at law. Those types of benefits will be regarded as merely ancillary. In contrast, an organisation which provides significant benefits to its members will likely find it more difficult to show that the provision of those benefits is merely a means of generating income for its charitable purpose. So, to finish up, I'd like to reflect briefly on the theme of today's conference, why we value charity. The fact that we're interested in asking and answering that question implicitly acknowledges that charities, as distinct from other not-for-profit, third sector or non-government organisations, have a unique value. We continue to recognise the distinction between charities and these other types of entities because society, not just those of us that are interested in the law of charity, regards charities as special, as an intrinsically valuable kind of organisation. So the restriction on the nature and level of benefits a charity can provide to its members, while still being regarded as charitable at law, assists in ensuring that charities will continue to be regarded in this way. Thank you.
Good morning, everyone. What's in a name? That which we call a social enterprise, by any other name, would it smell as sweet? There has been an ongoing love affair with social enterprises for some time, with plenty of benefits having been touted, including diversification of income streams and financial sustainability. One of the challenges is that the phrase social enterprise has no official legal definition and means different things to different people. Generally thought to involve a blurring of the lines of business and charity, social enterprise invokes concepts of B Corps, social entrepreneurship, impact investment, social procurement, and corporate social responsibility, to name a few. And social enterprise is often thought to run the spectrum between business and charity, with some leaning towards different parts of those spectrum. Social enterprise essentially uses commercial methods to generate social or environmental outcomes. We also know that in Australia, courtesy of Wet Investments, an organisation can look like a business, feel like a business, and smell like a business, but nevertheless, without a doubt, be a charity, because the touchstone of charity law is purpose and not activity. We at the ACNC are best qualified to talk about where charity and social enterprise intersect in Australia and the cases which cross our desks, which flirt at the edges. For ACNC registration purposes, both the Charities Act and the ACNC Act require an organisation to be a not-for-profit entity. As we know, this phrase is taken to have its ordinary meaning and is generally thought to refer to an entity that does not operate for the private profit or gain of individuals. Additionally, under the Charities Act, any non-incidental or ancillary purposes of a charity must be charitable purposes that are for the public benefit. And in evaluating public benefit, the Charities Act requires us to consider whether the purpose is directed to a benefit that is widely available. And so we have to have regard to all relevant matters, including a benefit from the purpose that is available exclusively to members, owners, trustees, founders, employees, officers, donors, associates, etc. So when does a social enterprise exhibit too much private benefit to qualify for charity status? One of the challenges in Australia is that often choice of legal structure at inception is a determining factor. And legal structures in Australia tend to be inherently for-profit or not-for-profit in nature. Skilled practitioners can tweak governing documents and implement hybrid models to try to capture the best of both worlds, but often compromises are involved. A social enterprise structured as a proprietary limited company with a standard constitution will generally not be entitled to charity status because it won't meet the not-for-profit entity requirements, because it will allow for distribution of profits, transfer of shares for value, etc. The ACNC intends to publish some guidance soon in relation to proprietary limited companies and when they will be entitled to registration. Another tripwire is where salary or wages or payments for goods or services are not made at on arm's length market rates. We like to see evidence that the responsible persons have given rigorous contemporaneous thought to these issues, and they can mitigate risks by doing things like getting quotes from other parties, inquiring into benchmarks for salaries and wages in a particular industry, establishing a remuneration subcommittee, implementing policies and procedures regarding related parties and conflicts of interest. And these issues are particularly pertinent in related party issues. It would also be remiss of me not to mention that experience would suggest that the majority of social enterprise players that choose a charity structure are doing the right thing and are genuinely trying to use entrepreneurial flair for altruistic good. We have the pleasure of engaging with these individuals at the coalface of charity registration and sending them off on the yellow brick road of hopefully productive work for the public benefit. But unfortunately, some get mired in the woods of private benefit, either through ignorance of the expectations or intentional wrongdoing. So these comments are directed at trying to help most to make their way to the Emerald City so as not to give the others a bad name, or to use ACNC Act speak to maintain, protect and enhance public trust and confidence in the sector. Thank you.
If you didn't hear, Jennifer just said be quick. Helpfully, I have slides, but it doesn't matter, they'll pop up at some point. Helpfully, Nicola and Sahanya have covered a bit of what I was going to talk about, which is great. What I am going to look at is the position for charities, not that want to do business, but that want to pursue their charitable aims through supporting and otherwise enhancing or promoting private enterprise of others. In terms of the context of why and how we value the charitable sector, I really support and echo what Dr. John said earlier, that charities are the engine rooms of solutions. And I think that one of the ways that we do support and value the charity sector is by supporting their expertise and their growth and development in this particular space. So if I flick quickly, or not, that's okay. Amy will sort it out if she won't, and that'll be fine. Talking about a charity that wants to promote business. Obviously, they need to have a charitable purpose, and in this space, one of the main charitable purposes will be advancement of enterprise or industry. Alternatively, you might be a public benevolent institution that is supporting economic development in economically marginalised communities. Both of those things can be charities, but the main issues come up for both of them, as the slide shows. Is the entity not-for-profit? And Nicola has really helpfully given you some of the information there about member benefits, so I don't need to go into that area. And secondly, is the entity for the public benefit? And so Hanya's given you some of the things that ACNC is going to think about when they're analysing you, but what I want to talk to you about is what some of the case law says in this area. Really, the question is down there on the bottom right-hand box, and I know charities law doesn't fit nicely into boxes, but I will continue to throw effort after foolishness and try and do that. Is your private gain that you're supporting for the public benefit? And then you're going to find your nice charity box that I would like you to go into. Or is your public benefit merely incidental to the private gain? In which case, you're not probably going to succeed as a charity. And if we flick again, yes, sorry. We have case law, helpfully, about this, and as you'll all know, it's developed differently in Australia and New Zealand, although the cases do like to say that they've adopted one another when it really does not appear that they have. So in Australia, oh no, we can go back. I don't need that slide, we can skip that. Oh. Done. This is our slide. So in Australia, we have the Tasmanian Economic Commerce Centre, your Electronic Commerce Centre, which you'll be familiar with, is one of our foundation cases. And that case showed that the purpose of assisting Tasmanian business and industry to adopt e-commerce and be competitive in the marketplace was charitable. The facts of that case showed that the entity was doing things like giving $30,000 grants to a company called Blundstone, which half of you may well be wearing Blundstone boots. This is not a struggling company at the time. That sort of support of private business was fine. It was charitable because the overall public benefit was to increase the economy in that area. Interestingly, in that case, the whole Tasmanian economy was considered to be depressed. The second case in Australia is the Commissioner of Taxation and the Triton Foundation. Again, a really good example of a foundation that, in that case, supported inventors and assisted them in their work to pursue the overall charitable purpose of promoting a culture of entrepreneurship and innovation. And in that case, the Commissioner tried to argue that the public benefit was only incidental to the benefit to those private inventors, but the court found completely the opposite. In fact, the assistance given to the inventors was ancillary to the overall public benefit of promoting a culture of innovation and entrepreneurship. And those two cases are really where the law sits in Australia. I'll skip over the Northern Land Council and Commissioner of Taxes because I'm being quick. But the next two cases, Chamber of Commerce in WA and South Australian employees, while they came up with very different outcomes on what seems to be almost the exact same factual scenario, they were based around the question of member benefits, which Nicholas talked about. But what I like about the South Australian case is that paragraph 152 of the judgment, the court said that while there are two separate lines of authority, and I'll briefly touch on the New Zealand line of authority in a moment, the Australian line of authority that is preferred and that is to be followed is what was set up by Tasmania Electronics and the Triton case. So that's where we sit in Australia. In New Zealand, we have Canterbury Development Corporation and Queenstown. They came up with a very different approach, ostensibly saying that they were adopting the Australian jurisprudence. Canterbury Development was, again, just about promoting private enterprise in the Canterbury region. It was about developing the economy of that area through supporting private business. And the court found that no, that's not charitable. It wasn't for the relief of poverty because it wasn't a sufficiently poor area. I think that's a bit colloquial, but that's what we'll say. And nor was it within the fourth head of charity because it was achieving a public benefit through private gain. So it was really flipping that coin, and the New Zealand courts haven't come to the position of saying the private gain can be ancillary to your public benefit. Similar thing was found with Queenstown Community Housing Trust, Queenstown Lakes, different fact scenario, but the same outcome, that trying to support private individuals to be able to live in a region so that they could contribute to the economy of the region by being employed there and providing much needed services, was actually providing private benefit to those individuals to have a house and was not sufficiently providing public benefit to the Queenstown Lakes region. So I find these, I've distilled them because I like to put things in boxes to their absolute minimum, to what are the essentials of this case. And I've just popped some questions up there that perhaps we can get into in question time, but what are the key differences between Australia and New Zealand? And really, was it the disadvantage of the relevant community that got us to these different ways of viewing things? Or do we have a fundamentally different approach to the relevance of activities in New Zealand and in Australia? Thank you very much.
Kia ora koutou, ko Stephen toku inga no o Tautahi Ao. It's a pleasure to be here. My name is Stephen Moe, and I've flown over from New Zealand, and I think it's really wonderful to share our learnings and learn from each other. The little bit of extra context to add is that I come from Christchurch, so we've had some events recently that have seen an outpouring of charitable relief And so that context has been critical for the shaping of my own thinking. Also, I used to work for an international law firm, and I was based in Sydney. So I was on George Street working, doing major multinational deals and things just a couple of years ago. So I come from the private, acting for banks and corporates, and have worn that hat as well. And since moving back to New Zealand, I've gotten involved much more, shifting gear into the not-for-profit charitable sector. And so things like now I sit on a board called Christian Savings, which is a charitable company which gives loans to churches and other groups. So just to give a little bit of context, I wear multiple hats. But the thing I wanted to, rather than get into detail today, I actually want to step back and talk about paradigm shifts. How many of you remember in the 1990s, you probably had this book. Does that look familiar? Magic Eye, a new way of looking at the world. It took the world by storm. Do you remember? I was, growing up, this literally sold millions of copies for about 6 months in 1993. This was the thing that was on the coffee table. And the point of it was that you could use your eyes to see things in a new way, a new way of looking at something. So those shapes there actually could be something else. And I think where we stand at this point in history is that there are paradigm shifts happening when it comes to charity and business. Tonight, when you're having dinner and you turn to the person to your right, let's just imagine that they say that they are about to start an initiative and it's going to help ex-prisoners reintegrate back into society. Immediately, because you come from the old paradigm, your thinking is going to be charity. It's going to be, that's such a wonderful initiative. Motivations of the heart. It's being driven by purpose. It's helping people come back into society. And how are you going to get your donations? Where are you going to get people to fund you? On your left, you talk with someone. They also have a great new idea. They want to have a new tech solution to credit cards and reduce costs. You immediately start talking to them about incubator programs and entrepreneurship. How many shares are you going to issue in your private company for profit? The mind is what's driving that venture. So in a way, you've got this paradigm. The old way of thinking is you talking here on the right about charity and matters of the heart. You're talking here about profit and company and matters of the mind. And the paradigm shift that's happening is a new way of thinking that says, actually, and this is being driven by the entrepreneurs and the next generation, not by those of us in this room. The new paradigm is saying, actually, surely we can combine the head and the heart, and we can have business which acts for good. So the paradigm shift, like you see here in the picture, is looking at the world in a new way. Looking at the way that we've traditionally thought about business and saying, actually, it should be about doing good. It shouldn't just be about private gain and how much we can return to shareholders in the next quarterly report. And equally, when it comes to charity, rather than being dependent on income streams which are at the whim of the government policy and at the whim of donations, it's about diversifying the income stream to actually say inherently in what we do as an entity, we are fulfilling a purpose. And that could be a charitable purpose. It's advancing a cause through the very action and the existence. Rather than taking money from the private sector to distribute it, it's actually saying through what we do, the entity is actually achieving social or economic good for the community. So that's the new paradigm that's coming, the new paradigm that's about to hit us. And the question that I have then is really, what does that mean for us at policy levels? If the old paradigm and the old way of thinking had to do with a binary of you're either a charity or a for-profit, then what does it mean in terms of the regulations and the rules which govern the very organizations if we're moving towards a new conception where the heart and the mind are combined and for-profit and not-for-profit begin to merge? And we move from extractive economies to regenerative economies where the organizations are actually about giving back to the communities. I'll just leave it there. You'll notice that throughout the talk I haven't used the word social enterprise. That's deliberate, because I don't want social enterprise to become a term that's something that they do. I think what we're talking about is bigger paradigm shifts that impact all organizations, and we need to make sure we don't categorize things as labels, because actually we need to move to a point 50 years from now where we see social enterprise as an intermediate step between the old way of thinking and the new way of thinking. Thank you.